Hello friends, welcome. Friends, recently there is an article which I saw in the newspaper which talked about Google antitrust penalty slashed by 75% as NCLAT partially overturned the CCI order. So this was posted on 29th March 2025 and this led to me investigating what this case is all about, and I downloaded the order from the NCLT website. So if you look at this is the order. This was the file name which is originally there in the NCLT system. So if I go up, and you'll see that this is how the order looks like. Now friends, why I am doing this video today? Because I have been following Google case from the very beginning in India. I did two articles which I will show you in my website. If you go and you can have a look at this. One is an article which I did on 25th of July 2023 which spoke about Google India litigation. So this article captures the summary of litigation which happened, which actually took place till that date, which I wrote this article, which is on 25th July 2023. Then I wrote another article which is on 16 March 2024, which spoke about Google versus Indian app providers, why CCI should follow the EU DMA blueprint. And this gives us the summary of the CCI case point by point. If you see the remedies which CCI mandated Google to follow, and these are the points which are mentioned here, which now has been litigated before NCLAT, and NCLAT came out with this order, which the headline is all about. So this was the CCI order, and this is the NCLAT order, which came out on, I think the date was 20th March 2025. So that's the overall summary. Now friends, what I am going to do in this video is to create a summary presentation which will talk about that what we gain as Indians, what we gain as app developers, because all these complaints which were lodged against Google was to take care of the app developers' interest, right? That was the whole objective. Why are we wasting so much of our time fighting Google? So that's one. We will summarize and see what we have actually gained. Anything materially we have gained, or we lost everything, right? So that's one. The second is that Google and Apple cases are almost similar in nature. Google has been fighting the Indian Competition Commission of India, I think for last 3-4 years. I don't know exactly when the cases started, but it has been a long time Google has been fighting cases in India, but Apple cases were still there. There were complaints against Apple, but nothing came out from CCI, right? So Apple may be more harsh as regards developers are concerned, and there are a lot of constraints that you can't do side loading, and there are, even today you have to go through the Apple billing system. But the order came against Google. Google faces a lot of fine, but Apple gets scot-free. And it surprised me also. There was an article which just came out recently. This is in Business Standard. I think it published an article which got initially published in Reuters. So it said that CCI backs Apple's in antitrust case, denies match startup and sensitive data. I really don't know what this case is all about, so I will not like to comment. But what I understand is that Apple was similarly investigated as Google was, but nothing came out of CCI. That I understand. Okay. So now let's go straight to the PPT. So let's look at what is the real outcome Google versus CCI. This is what we are interested in, because what is the point in going clause by clause, what the argument CCI made, what Google responded, what NCLT said, what Supreme Court said, does not matter, because you will get lost. As a layman, you will get lost. Though I have gone through the judgment. As an individual, because I don't want to do any loose work. So I go through these judgment, and that's why these articles that I write are so detailed in nature. You see? These are very detailed articles. These are not just articles which I do, by hearsay, by reading newspapers. I read the judgment word by word, right? Without reading the judgment, I don't do anything. So both these articles, the first article which I mentioned here on 25th July 2023 I have read through, and I have given all the remedies which CCI has has issued in their judgment or directed Google to follow, and what were the Google's option, right? So these are all written. You can go to my website and have an access to this article. And in the other article, which is based on the March 15, 2024 CCI judgment, which currently the NCLT, it was challenged in NCLAT, and NCLAT came out with their own judgment, where many of the provisions have been diluted. Here also, all the provisions have been clearly mentioned. So let's go now straight to the PPT. What is the outcome? And we will do a summary presentation rather than getting into too many details. So the first case is the Android ecosystem abuse case, and there was a penalty of rupees 1,337.76 crores. Now this penalty, probably Google has paid 10%, and it is being litigated in Supreme Court now. Okay, so this case is still ongoing, and let me give you a summary. The CCI order came on 20th October 2022. Allegation was Google abused its dominance over Android OS. Penalty imposed was rupees 1,337.76 crores. NCLT on March 2023 upheld the fine and struck down 4 of the 10 directives which CCI had issued. Right? We might, if I get time, I'll go through those directives and I'll tell you why they did that. Supreme Court, in Supreme Court, appeal is going since 2023. So this is the case, the first case, where the most important part is the payment, the penalty is still on Google's head. It has not been quashed. Second is the second slide of the same thing, Android's case, Google, what it lost and what it retained. In summary, the liability of rupees 1,337 crores is pending SC decision. It forced to relax Android licensing to OEM. It must allow search engine and app choice. Right? So that's what it basically lost. What it retained, 4 of the major CCI directive was struck down. Example, side loading and uninstalling. It is just a bullet point, but details you will see in my article. I am going to show you the article. Business model and bundling intact. Service fee structure unchanged. Maybe you may not be able to understand it, but when you go to the detail of the article, you will understand what we are talking about. Because the case documents are pretty voluminous. People will get lost. Maybe you have to spend 2-3 days, reading these boring documents. It becomes very boring to read these documents. Anyway, now come to what Indian developers gained. Indian developers gained nothing. Let me tell you, nothing, zero. And if you ask me why, because the main contention of Indian developers was the service charges, which is 15 to 30%. And that service charges, neither CCI gave any remedy, nor NCLT gave any remedy, nor the Supreme Court likely to decide the decision. And let me tell you, in both the judgments, both the cases, the case 1, which is the Android case, and the case 2, which is the other case where Google forced the app providers to use their payment system. In both cases, this whole service charges of 15 to 30% fell apart. Nobody gave any order. Nothing. It actually vanished in oblivion. So if the service charges, which was the main bone of contention, which is called the Lagan tax, is not even question of any litigation or discussion, then what is the point in wasting so much amount of time in all this order? Because let me tell you, see, since I have, gone through a lot of patent cases, because with Qualcomm, I actually had a 20 years experience in Qualcomm. And let me tell you what the problems that we face. So let's say I'm trying to compare patent cases with the service charges which Google is trying to charge from their app developers. Now, in case of patent cases, what happens is that you develop a patent, you file, you get your patent registered, and then you are expected that everybody will follow the rules. And then they will come to you for licensing, and then the handset is going to basically, whatever handset that they manufacture, they are going to pay a fair share of their handset price as royalty. Now, what if a manufacturer does not pay a license fee? As a technology provider, what kind of leverage we have? Nothing. Let me tell you, nothing. Why? Because getting an injunction in cases of royalty, non-payment of royalty, extremely hard, because you have to go through lot of processes. Injunctions are not easy to come by. What is injunction? Injunction means that you prohibit that manufacturer to manufacture handset unless they have a license agreement with the patent holder. That is with a lot of caveats. You have to show good faith in negotiation. You have to demonstrate that the licensor has, tried to license their technology. Okay, so there is no leverage. But in case of a typical service fee payment, where an app developer has no other recourse but to use the Android ecosystem, whereas an app developer has to use an Apple iOS ecosystem. Let's say if he does not pay license fee of service charges of 30 to 15 to 30%, then the app, the OS company, which is Google or Apple, can delist their app from the service, from their Play Store or the iOS App Store. You can't do anything, because then in that case you have to go and litigate that case in the court of law, and they can very clearly say that, look, if you don't pay us, we are going to delist you, right? But I'll tell you what kind of advantage that the payment system, the mandatory requirement to go through the Google payment system has given the app developer some leeway, but it has not prevented this whole risk of them getting delisted from the app. So these OS providers, Google and Apple, has got huge power, right, against this developer. So that's the distinction which I wanted to draw, because this is very, very important, friends, to understand. Now let's talk about the Play Store billing case, right? And then if you have time, we'll go through the details of these two cases in my article. So the case 2, Play Store billing case, was a billing abuse, and a penalty was imposed by CCI. And then it was upheld, first it was the Director General, then it was CCI, then this number was 936 crores, 0.44 crores. The order came on 25th October 2022. Allegation was forced app developers to use the Google payment system. Penalty was this much. Then NCLT upheld the abuse. They upheld the abuse but reduced the penalty by 75% to 216 crores. And Supreme Court appeal may be expected. I don't know whether they will appeal or not. There will be an expectation that we will appeal. So who lost what Google gained and what the app developers lost. So the Google was mandated to allow an alternate billing system. They call it UCB. Now they were doing so for other small app providers, not for those gaming apps, because the gaming apps have got high volume. But later they changed their policy to include gaming apps also under the UCB. UCB means that if you want, you can use an alternate billing system. Now tell me, why would Google want every app developer to use their billing system? Tell me, you probably will have the answer. The reason is that it becomes easy to administer service charges of 15 to 30%, because then you don't have any ambiguity that how much revenue that they have collected and how much license fee and how much service charges they should pay. 15 to 30% they should pay. So that is the main motivation of them to go through the Google billing system. Okay. Now, if you go through an alternate billing system, you have got lot of problems. Let me tell you. First, you have to maintain a billing system. Then Google still has the leverage, because if you misreport, they will delist you from the Play Store. So there is definitely a transactional cost which Google has to incur, because they have to rely on the data that you submit, right? How much payment that you collect. But if they find out that if you are fooling or you're telling lies, then you risk delisting from their system, right? So that is the huge risk which a patent developer does not have. And that is why I explained to you that what kind of leverage these systems or these OS providers have. So increased auditing, I told you, and compliance burden on Google. Abuse confined by the tribunal. Slightly they have confined the abuse by the tribunal. Commission model is still intact. 11 to 13%, still control delisting, no cap on service fee or open platform obligation, because service fee is not being discussed in both the cases. So Indian developers actually got nothing, right, in real sense. Play Store case, what the Indian developer gained? Right to use an alternative billing option. Now, if you use an alternate billing option, then what you have to do? You have to maintain it, you have to pay. So it is not easy to have an alternate billing system, my dear friends. It's very difficult, okay? Still have to pay a license fee. They have given a discount of 4%, but that 4% is not good enough for you to have motivation of a separate billing system. must manage an audit and report, and no cost relief on structural benefit. Nothing. Okay. Then final takeaway, Google versus Indian app developers. Google preserved the core business model in both cases. 15 to 30% commission not disputed by any of the courts, both the cases. Nothing has happened in this, though this became the main bone of contention for fighting all these cases. Developer receive symbolic rights, no commercial relief. Google still hold platform leverage and enforcement tool. Penalties and minor structural powers are untouched. This is what the final takeaway. So we have been litigating and we have not got any benefit, right? And those penalties are peanut. And what will happen after these cases get finalized? Indian app providers will have no further leverage because they have discussed and debated and litigated each and every concern that they have, right? Net outcome, symbolic means commercial status quo. Developers got choice, Google kept control. That's all happened. Now, friends, this is just a summary of the article because I didn't want to get into the provisions, the legal provisions, because if you are interested, I would suggest that you go through this article, this article, Google India litigation, which has clause by clause of CCI remedy and Google's option, what Google can do in order to get around the remedies, and why those NCLT has set aside certain of the CCI provisions which have been clearly mentioned here. What was the reason for NCLT setting aside some of the CCI's direction to Google, right? So this is one very important article, very elaborative. Everything is written here. You can go through it and you will understand each and every aspect, which I don't want to go through in this video. Then the other was the Google versus Indian app provider, the current judgment of NCLT. Here also, all the remedies which CCI mandated for Google has been discussed here. So I'll just give you a summary. Remedy number 1 is sustained by NCLT. This one is also sustained. This one is also sustained. Remedy number 4 is sustained. 5 is sustained. And 6 is not sustained, right? What was that? Google shall not impose any condition, including price-related condition on app developers, which is unfair, unreasonable, discriminatory, disproportionate to service providers or the app developers. This has not been sustained by NCLT. Looks strange, right? And then 7, this has not been sustained, right? So this has been struck down. Google shall ensure complete transparency in communicating to app developers, service providers, and corresponding fee charges. This has been struck down by NCLT. This was the directive of CCI. Then 395.7, right? 395.6 and 7. 6 and 7 is not sustained. 395.8 is sustained. Google shall not discriminate against app facility. The specific clause address Google service charges reasonableness. Clause 395.6 on page 188 lack clarity, precision, rendering it challenging to enforce in practice. So you can go through it. And then we have got 396 on penalties, which is clearly reduced by NCLT in their judgment by 75%. So this is in net. Now the main point about this article, this video is also that Google went through all the trouble. They have a much open system for the developer, and Apple has got a much more restrictive app store system, which is constrained compared to what Google app store system is. Still, they are out of litigation, so it will be very interesting to see how long they are able to get away from litigation. Whether Apple litigation in the India, if at all it emanates some point of time, some of the remedies or some of the advantages, or you can say benefits that Google was able to draw in this particular case will get unwinded in future or not, or this will become a baseline case which Apple will also go through in future if at all the stage comes. So that's all, friends, in this video. I hope that you like this video, and let me know if you have any kind of comments in the comment section. I will come back with a new video next time on a new topic of interest. Thank you very much, friends.